Hello and welcome to the Agents Angle, and thank you once again for taking the time to join us as we take our weekly dive into the football agents world. I'm Jonathan Booker.
And I'm Peter Paleologus. On this episode of the Agents Angle, we look at a dispute between a famous club and an agency over unpaid agent fees that now have been reported to the English Premier League authorities.
Also, we look at whether a selling club or even the agents involved in a transfer can be held responsible for a problem that makes the player ineligible in the future.
All that to come on this episode of the Agents Angle.
Now, the challenges for this episode of the Agents Angle, Peter, are that one, we try and avoid for as long as possible the use of that four-letter acronym that has plagued us for so many episodes now. And it may well be considered a four-letter word for some people, given the amount of times we refer to it. And two, we try to make this episode a bit shorter than we have had for recent episodes of the Agents Angle. Now, we don't want to cut out valuable content, but we do want to make the Agents Angle as enjoyable and as manageable as we can for the listeners, as well as it being informative.
Yes, Jonathan, we've gone on a few episodes quite long, and obviously we've had a lot of great guests. We have a good lineup of guests coming up on future episodes, but this one, shorter, focused on really hot topics.
Yeah, and we'll get straight into those topics. The first one, as we mentioned in the introduction, it involves a Premier League club, and the original article actually carries the headline, "Threat of legal action by an agent against an English Premier League club over unpaid fees." The original article was in the Daily Mail on the 19th of October, so approximately a week ago now, and it was by Matt Hughes. Now, the club in this case is Everton. Now, there is problems for Everton at the moment with an ongoing investigation into alleged breaches of FFP, financial fair play, which could even jeopardise their Premier League status if they get a substantial points reduction. There's also a stalled takeover. And sadly, in the last week, their chairman, Bill Kenwright, passed away, who was recognised as a true gentleman, a true fan of the club, and always, I believe, wanted to do the right thing by the club. But those woes have been added to recently with this article. And as I said, it was first reported in the Mail. And as with all of these reports, we have to be quite careful, as we have a limited amount of information available to us, both from the agent in dispute and also from the articles. There's even less from the club, it would seem. It's also worth noting that for many mainstream outlets or football publications, they haven't picked on this. So we're taking this story with a pinch of salt, but it is an interesting subject. So we're going to hypothesize on what has gone on, what is going on, and what may happen in cases like this. Now, what's been reported and alleged is that it is an international agency owed several £100,000 over an agent fee related to an international signing. The definition of international agency isn't clear. It could be a smaller agency that operates across different territories, which is not unusual in a worldwide game. The agency claims they acted on Everton's behalf as the engaging club, the buying club, in recruiting a player in the 2021-2022 season. The club is alleged to have declined to pay the invoice from the agents, and it's claimed the club offered a settlement on reduced terms. But that, again, is something that's heavily disputed. The agency subsequently has sent multiple legal letters to the club and even engaged a debt recovery service. The agency has tried to resolve this with various clubs' officials, but subsequently, from that frustration and not getting a response, they seem to have reported the club to the Premier League. Now, we're not going to go into matters of the agency lawyers raising it with the Premier League, because that is reportedly based on auditing irregularities regarding the potential takeover of the club, as that isn't our place and it distracts from the agent-club relationship on this matter that we want to focus on. But this whole issue raises so many questions for me. We don't know the terms of the agreement, as I said, and what is the basis of the dispute. For example, the amounts, the schedule on the payments, whether the agent met their obligations, or even who signed it off and whether they had authority. The renegotiation or settlement of what was owed is also in question. Was this an official renegotiation or settlement, as in mediation or some other dispute resolution, with a legally binding agreement off the back of it? Or was it very much amateur, back of a fag packet and a handshake type stuff, which is not uncommon in some football transactions? The absence of any mention of the FA and the Rule K arbitration process in such a dispute between football participants is a particular surprise to me, because that would be the normal route. And we do have an episode coming up with an expert on Rule K and football arbitrations through the English FA in a future episode, so keep a listen out for that. Now, I understand why such disputes sometimes don't go the Rule K route when they're smaller amounts, because it's just not cost effective, but this is reportedly several £100,000. In it not going to Rule K, there's something not quite right here, either in the agreement, the transaction, or the alleged settlement, meaning there's a reluctance on behalf of one or both parties to go to Rule K and the FA. And the other thing is, if all matters are above board and the paperwork is correct, such as the agent representation agreement with the club, the transfer documents, those should all be with the FA and they can and should act. Plus, because this is likely to be an international transfer, this should all be detailed on the FIFA TMS, should it not, Peter?
It should. I had a look at the article as well, Jonathan, and it's unclear to me, based on the way it's sort of described, not just the breaches, but also the international agency and what's going on. But I think, firstly, this is an interesting situation going forward. A lot of agents I speak to are excited to become club agents. As we know, club agents under the FFAR, FIFA Football Agent Regulation, get 10%, and there's no limit on contract with the club in terms of 2 years as it applies to players. However, this article covers issues which can arise between clubs and club agents. You mentioned Rule K, but there's an international dimension. The article mentions an international agency. Were they registered in England? I mean, would a club give a mandate to someone who's not registered? Now, club mandate to an agent bring interesting issues. Firstly, what work was done by the club agent? What were the reporting lines? Who liaised with the agent? Who told them what they can do? Were the commissions based on results or success, or was it fixed, or was it payable over a period of time in installments? We don't know. Now, it's quite interesting. What about the selling club or the club that the player left? Who dealt with those issues? Was it the club officials, Everton? What about the club agency? So we don't really know a lot of these issues, but this article highlights what maybe can go wrong.
I think the interesting thing there, Peter, you've used the word mandate, and you and I have plenty of conversations about mandate. It means different things in different parts of the world. And if that is the case, and there is one form of a mandate here, the stock line from the FA has been for years, we don't recognise mandates. They recognise subcontract agreements, they don't recognise mandates. But I know they're part of the business in many parts of the world, and that's the way it happened. Now, looking at this from the perspective of the agency involved, I can totally appreciate their frustration and the need to hurry things along for what they think to be right and fair, if not just to get clarity on the situation. Going to the media and effectively going public demonstrates this frustration for me. And the agency world generally keeps such things quiet on things like this because it can damage relationships and reputations. And it also can demonstrate weakness and vulnerability in such a competitive industry. Plus, this is cash flow for the business. And as with any business, one non-payment or even a late payment can put a lot out of business. For me, going to the Premier League, however, is pointless, as the Premier League have talked about agent regulations for years, but nothing can show no real interest. When the annual declarations come out from the FA on agent fees paid, the Premier League are quick to crow about it, talk about regulating and so on and so forth, and quickly that disappears. And that's happened for several years. However, if piggybacking the financial fair play affair and the investigation and going to the Premier League by the agency involved indirectly helps their cause in getting a resolution or even some clarity, I can see their logic in doing that. Now, as I mentioned previously, we're going to look at Rule K in a forthcoming episode with disputes of this kind and others in England. But in this particular case, not going down the Rule K route, and as is reported, going directly down the court and litigation pathway, will firstly be very costly and likely end up being passed back to Rule K arbitration process if the agreements between the club and the agents are compliant with standard FA regulations and lodged with the FA. Now, the club, according to goal.com, in one of their reports on this, there's a dispute as to whether the club formally instructed the agent to act on their behalf. And this takes us back to our interview with Matt Slater on the previous episode of The Agent's Angle, episode 15, of a different agent story and an agent communicating with a club chairman and there being confusion in the conversation there as to whether an agent commission was due. So overall, at the most basic and crudest level for me, this all comes down to the fact of whether the agent has a representation agreement with the club in relation to that specific transaction and whether that's filed with the FA. If they haven't, why not? If a representation agreement is not filed with the FA, it is arguably a breach of the regulations, although it may still be a legally binding agreement between club and agent. So, as with so many disputes in football, this seems a real mess and massive confusion. And there is, for me, more than a whiff of something not being done correctly or not being communicated effectively here. And if the regulations have been applied correctly, it should be remedied pretty quickly without the need for threats of litigation, debt collectors, or going public in the media.
I agree, Jonathan. Firstly, for our listeners who don't know, Rule K is the name of the English Football Association's arbitration process. Just make that a little bit clear. I think here it's about paperwork. That is fundamental. That is important. We know that a lot of times agents will just work on WhatsApp messages. Very, very common in our industry. But there's got to be an onus who submits authorization agreement or sub-authorized agreement or representative agreement to the FA. Was one lodged? However, it seems to me that this dispute, by moving to the media, has moved to more of a brinkmanship position, and that is difficult. But we're hoping, obviously, for Everton and the agency that they can resolve this without taking it any further. We can speculate, but this case highlights what maybe can go wrong with the club-agency arrangement.
Now, the next story, and this story has developed quite quickly over the last week and yet further over the last 24 hours, as last night it was reported the player in question has been banned for 10 months from football by the Italian Football Federation for betting offences. Now, there are additional penalties along with the ban, some absolutely necessary and some I would say are more questionable. This is not a straightforward issue, is it, Peter?
No, it's not.
Many levels.
This is a difficult issue. It's an emotional issue. Gambling can be a scourge on the game in terms of making it difficult for a lot of people, a lot of players, etc. But it's also about transparency. We also know that players are not allowed to gamble. I mean, each country's got its own rules, but it's a very, very difficult case. And I would say that there's a few layers here. The Italian football authorities are very hot on the issue of gambling. It cannot be escaped because of the threat of match fixing generally within football. And the Italians have a lot of pride in their football. I think Italian football, or Italians in general, don't want any further scandals or alleged scandals to occur again. And this reported case, Tonali, a fantastic player. I mean, Newcastle, pretty sad to report of gambling addiction. We can't speak. We're not specialists on the matter, but the agent really emphasized that we really need to help clients with such problems, even though it is a very difficult issue. Tonali's agent, Giuseppe Risso, he basically had I don't know if it was a press conference or made a media release, but from the Italian embassy in London, he did admit Tonali had possible addiction to some sort of gambling. I don't think it was related to football, but I'm not sure. But he was very grateful to emphasize that the player and the agents and the team around him had received a lot of support from the Italian Federation. That feeds in back to Italy is very strong on ensuring they avoid these sort of situations. However, if it does occur, you have to support the player.
Yeah, from what I can gather, the agents in this has tried to do their best to get ahead of this situation, help the player, and also put in place some crisis management. But the key thing is doing the best for the player. All agents have had an experience of such things to a varying degree in different natures. I know I have. I don't know if you're in the same situation as well, Peter, and you do your best for your clients. And your job as an agent is to do the best for your client, if not put their interests ahead of yours, even if it doesn't sit comfortably or is even detrimental to you. Now, away from that, there are a lot of people talking about whether Newcastle could possibly demand compensation from the player's former club, AC Milan. But I would say that is very much down to how thorough Newcastle were with the contract and the recruitment process. And if such possibilities were included in the transfer arrangements of such problems, or the selling club were asked specifically to disclose any such problems they were aware of. Injury-wise, of course, clubs have players go through very rigorous medicals on most occasions to ensure they are fit and not harbouring medical problems or susceptibilities before they actually sign the player. I would actually argue it's not the selling club's responsibility to declare if a player has knees made of rice paper, but the engaging club, when transferring a new player in, has to exercise due diligence in their recruitment and or put caveats in the transfer agreement with the selling club and or the player to safeguard their interests and their investment as much as possible. Granted, we're not talking about a company takeover where there's rigorous checks, but with the investment reported to be a 70 million transfer fee and the player package on top of that, you would have thought impeccable due diligence has been exercised before making that investment. It's well known clubs investigate the character of players, whether it be picking up the phone to a former coach, a former teammate, or an agent, or anybody else who knows that player. And in some cases, I've even heard of clubs hiring private investigators to establish the character and background of the player. So I find it hard to believe such questions haven't been asked in this situation or such circumstances investigated.
I agree. Due diligence and background checks are undertaken by clubs or consultants that they employ on key players these days, especially when you're looking at these amounts of the transfers at the top end of the game. And agents for the player would need to disclose, when asked by a club, any injuries, maybe why there was a lack of playing time. Was it a coaching issue in the previous club, if that's the question? Family situations and dynamics in order for the new club to accommodate the player. But the agent doesn't do all the background or character checks for the club. They're representing the player. So they're not always asked about any other habit. Maybe if they were asked about and they knew about a betting habit, that would probably be disclosable. But we don't always get asked these questions when representing a player. However, if the questions are asked, the agent needs to be transparent across all the issues. There are addictive issues, player behavioural issues, family issues. All these things, the club can get the information from the agent, but the agent doesn't know always everything, especially agents who have got a lot of players and maybe not always spend time with their players day to day, especially if the players are dispersed in different countries. They don't know all the internal situation with the player or their habits. So it's an interesting one, but I would say that we're becoming more litigious in every part of life in a lot of countries. And this could happen where if misrepresentations or non-disclosures are made, sooner or later, agents may also be responsible going forward, if they're asked, of course, or they're not being transparent.
Now, in terms of the player, you're probably better positioned to comment on this than me and possibilities of labelling such things as gross misconduct and breaches of an employment contract. But I would argue such action against the player in this situation is unfair if there is a genuine addiction there. And arguably there is an option to maybe vary the contract to balance out the losses from the suspension and a demonstration of goodwill from both parties. Although this is football and demonstrations of goodwill are valuable, if rare. Is this really gross misconduct? This is a personal and I would say a health issue that the player didn't consciously cultivate. If the player committed these offences whilst in Italy under a contract to another club, I don't think he can be guilty of misconduct at the new club. I do, however, think that some third parties could be at risk of action by Newcastle if they were asked about it and or had a duty to declare. That could be, again, the player. Was he asked? The player's agent. Was he or she asked of such issues? Either the addiction itself or an investigation. The agent acting for the buying club, if there was one, in not doing adequate due diligence, if that was part of their role. the agents acting for the selling club, again, if there was one, if they were asked about the issues as well.
Yeah, we don't know the facts, but there's got to be some accountability. And if people were asked, whether it's the buying club or the selling club, then they would have to disclose. I think I mentioned that earlier. However, there's another issue. Has the club or the agent, firstly, the club who's employing the player, there's a league code of conduct, there's contract obligations that relate to different matters like betting regulations. Secondly, has the agent gone through the contract and said, there's no betting, with social media, you need the permission of this? You go through those code of conduct type matters. We know the Premier League handbook's got a lot of content there, but there is a code of conduct for players as there is for clubs and officials. It's all to protect football and the integrity of football, but also protect players, and players should know their rights and what's expected in certain countries. But also the agents, when they read the contract, will say, you cannot do this, you cannot do this. At training, you have to come this, all those things. That's our job. So really, there's an education piece here.
I think the key thing is there's a duty of care there from so many people.
Yes.
And there's an official fiduciary duty from these people who've got contracts. And we are hypothesizing on this case. We're just using this as an example, as I think I'm pretty safe in saying there's probably other cases that haven't come to light. There are issues here. But above all, for me, Peter, I wish the player all the best in getting rid of these demons and that he comes back stronger, both for his benefit and for the club. Yes, he's a very talented star footballer, but at the end of the day, he's still a human being. We've all got our weaknesses, our vices, and our susceptibilities. And as with a lot of football regulations, they aren't always as clear as people may think, whether they're gambling regulations or something else. They are open to huge misinterpretation and often are subject to miscommunication. And there is, of course, the inconsistencies in regulation between different countries as well.
Yes, you're not going to like me, Jonathan, but I'm going into another two countries and their national football agent regulations. The two countries are Iceland and Belgium. I'll start with Iceland, fascinating country, has had some great campaigns in football recently. And I just want to talk about a couple of things that I found in their national football agent regulation, which diverge from the FIFA football agent regulations, which agents have to follow. Now, in other services, and I had to translate this because it was in Icelandic, it wasn't in English. They mention other services, which includes legal advice, financial planning. We've seen that before in FIFAs and a lot of national football agent regulations. But they also have another service called obtaining football-related information. I don't know what that means, but it seems quite wide and comprehensive. So an agent who's obtaining football-related information, that's another service, and can charge that it's outside the fee. So that is quite interesting, and I think that's something to follow. What is obtaining football-related information? They also, in their regulations, talk about the term agent service and basically define it as agent service in football. So when they talk about services, it has to be in football. So anything outside, you can do what you want. It only governs what's in football. And the other thing is the KSI, which is the Icelandic Football Association, has a disciplinary and ruling committee and also an ethics committee, and they can impose sanctions on agents for any violation of their regulations. Now, I want to turn to Belgium. This is a very interesting one for me because Belgium, we know there's a lot of agents, a lot of people interested in the Belgian market. It's a great market for players to move into bigger markets, good youth development, good standard of football, a market that a lot of scouts watch. And in terms of the national football agent regulations, there's some very interesting provisions or clauses, I should say. Firstly, any royal decrees and also the Belgian anti-money laundering legislation applies to the regulations and to agents. So their agent regulations are subject to anti-money laundering legislation. And when I say royal decrees, that's government decrees, whether it comes from Wallonia or Flanders part or Flemish part of, because I know they're pretty much a federation in that regard. Doesn't matter where it comes from, any decrees, they apply to agents, but more importantly also the anti-money laundering legislation applies. So agents can be investigated for money laundering, and that's specific in their regulations. I have not seen that before in any other national. I've seen tax, I've seen audit, but I haven't seen prevention of money laundering. The other interesting one is the representative agreement in Belgium has a clause where So when you do the representative agreement, we've got clauses of the parties, the fees, the services. In the Belgium agreement, you've got to have and read and accept. There's a clause that you must have read and accept the contents of the FIFA regulations for agents and also the Belgian regulations for agents. You have to include that in the contract that all the parties to the rep agreement have read and accepted those regulations. Also, in terms of the national dimension, so a dispute between a Belgian player and a club, or a Belgian agent and a player, or a Belgian agent and a club, there's an arbitration clause. You can include an arbitration clause which explicitly says that the Belgian Court of Arbitration for Sport is the arbitration body to hear national disputes. That's good. That's clear. You have to put that in, and it protects the agent in terms of a national dispute in Belgium and the player and obviously the club. The other couple of things before I move on is that the Belgian FA has a national chamber for agents, and they're authorised to impose disciplinary sanctions on agents for violating any regulations. And the other interesting one is we know the FIFA is bringing in a clearinghouse in terms of the payments in due course. Maybe in 2 years, it may apply to agent payments, agent fees. The Belgian Federation has a clearing department, and I think it's a bit like England. No longer is it required approval from that department for representation agreements. Before, under the intermediate regulations, you had to also get approval from the clearing department of your representation agreement. So very, very interesting in Belgium. Quite a few differentiations from what we see at FIFA and what we see some other national associations, Jonathan.
I think that football-related information category can go in the same file as a link to Germany, can't it?
And with that link to Germany, I'm turning to the next topic, which is the European Court of Justice ruling coming up on the 21st of December in the Super League case. Now, the Super League case is the case where one of the promoters has taken UEFA, in this case, to the European Court of Justice based on anti-competition rules, saying that UEFA is pretty much a cartel or controls everything. And they've got a dominant position, and it's very anti-competitive and in violation of EU laws. I won't go too much on the legal side, but this case is currently in the European Court of Justice, which is the ECJ, and they want to challenge UEFA's regulatory obligations as their regulator, but also a competition organizer. And that is the conflict in European Union competition law. That they run a, if not a cartel, a monopoly, I could say. Now, that decision will be probably a big shake-up in European football, probably since Bosman. And the reason I raise that decision is because we have another European Court of Justice decision, probably next year, that's been referred to from the German courts mainly. And that relates to football agents and several football agents who've taken legal action against FIFA. And one in Germany got an injunction where FIFA has plans to regulate, and we know, caps on commissions, the licensing system, dual representation limitations, etc. So whatever is decided in the Super League case, because it's going to be a lot of anti-competition elements there, may affect the agents case. So we need to look at that very clearly. But also, the potential ramifications are not just the legal side based on the decisions, but also the business side in terms of the Super League case. And that's because if the European Super League gets the go-ahead and that people can set up a separate competition to UEFA's Champions League, for instance, and include some of the mega clubs or the big clubs there, who does that benefit from the agent side? It might be 12 Super League clubs, all looking for the best players. That a certain type of agents will probably have the players and access to them. So it does apply to agents in the Super League case as well, because a new league means possibly new money, new interests, new opportunities for agents, and different focus of the way they may present players. So there are implications on the business side, not just on the legal side, Jonathan.
So we go from super agents to super Excel agents, super size agents, and mega agents. It's certainly going to be a field day for the media, but it's going to be very busy at the ECJ with so many different hearings going on in football. FIFA, I understand, has got quite a few hearings that it's got to go through.
Well, I'm afraid that the lawyers also win in this. And I just want to cover one more important piece of news. And that's FIFA's having its football law annual review in Tokyo next year on the 1st and 2nd of February, 2024. And it's going to focus on different topics that affect football. This football law annual review is quite important for agents because there are several topics listed that affect agents. One is going to be presented by Daniel Cravo, a Brazilian lawyer, a fantastic Brazilian lawyer, on player transfers, do's and don'ts. And as agents, we're always learning. We always want new insights. We always want the inside word on doing deals. That is going to be a very interesting session. And this annual review, it will be streamed by FIFA as they are previously, but that will be a very interesting session. We've also got the FIFA clearinghouse, which may apply to agents' fees down the track. But probably the most relevant one, I should say, Jonathan, is legal proceedings around the new football agent regulations. I know that Emily Devlin, the FIFA Deputy Legal Officer, will be presenting on that. And that will be cases in the Agents Tribunal, probably the first few cases if they go to the FIFA Agents Tribunal. And also, what are the trends? What kind of cases are being heard in the football agent space? So that conference is going to be not just a FIFA focus, but definitely an agent focus.
Yeah, the 2-day program, I've had a look at it, and compared to in the past, it seems quite whether directly or indirectly agent related with transfers and tax. And I noticed disciplinary system in the English game as well. So that's an interesting one, especially when we're still waiting for the Rule K over the National Football Agent regulations from the FFAR on that. So that's quite interesting. And of course, no doubt FIFA will distribute their statistics in relation to agents. So that will keep me busy for a couple of days picking that apart and seeing what I can extrapolate from that. It's quite sad, isn't it, really, me doing that? But there we go. Some good stories, not all good news today, folks. Apologies for that, but we hope you found it interesting. We're going to bring this episode to a close now. As always, follow us on social media. Send us your questions, send us your suggestions for topics that you might want covering, and also any guests you want to hear on the show. Please give a thumbs up, a like, a repost on social media, and of course, via the various podcast channels. Make sure you leave a positive review and a positive rating. So from me for this week, it's farewell.
And before I say bye, Jonathan, here at the Agents Angle, we're very big on player care. And really, the terrific player that Tonali is, we're really hoping he comes back stronger as ever. So bye from me for now.
Absolutely, Peter. I don't think anybody can disagree with that. Bye, folks. Take care.
The purpose of the Agents Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.